Hello everyone and welcome to Patexia web series. My name is Pedram Sameni. I'm the founder and CEO of Patexia. Today we're going to cover the basics of patent and prior art. So I'll start by giving you a just brief introduction to intellectual property, the definitions and types, then explain the patent and what is patentable. After that, we'll review the definition and types of prior art, and after that, at the end, we cover different types of patent search and the best practices and strategies for patent search. So, and we conclude by giving you some online resources for patent and prior art search. So, before we get started about this Patexia web series, actually, this web series, we call it IP Matters, and as part of our mission to bring transparency and efficiency to the IP world, we're committed to educate our community on important matters in IP. So this is going to be our first monthly webinar, and we hope to have more in the future. We plan to cover topics such as defensive publication, business of IP, strategies for licensing search, patent analytics, and we welcome your suggestion. If you have, if you would like to learn about something, please feel free to email it to webinar. Your questions during or before the webinar by tweeting it to @Patexia using your Twitter account. Okay, so why IP matters? Before we get started, I want to show you the difference between there is a little bit of delay actually between the slides, so you should see it shortly. Okay. So it's going to take a second. Okay. So why IP matters? If you compare the, for example, S&P 500 companies, the market cap, 4 decades ago, back in the 70s, you will see that over 80% of the market cap of these companies were made of tangible assets. That means like, for example, land or equipment. Today, this ratio has been reversed. So, for example, today, over 80% of the market cap of S&P 500 is made of tangible assets. So this shows the importance of intangible assets, and this shows the importance of intangible assets and intellectual property. So what are these intellectual assets? So by definition, basically the intellectual assets are the intangible assets of the company. This includes, for example, human resources, know-how, experience, people knowledge, insight, and the subset of these intellectual assets is called intellectual property, and it has 4 types: patent, trademark, trade secret, and copyright. The legal definition of intellectual property is basically the legal right that can be asserted in court. So having said that, let's get into patent and patentability. So patent, by definition, is a set of exclusive rights that granted by a national government to an inventor or their assignee for a limited period of time in exchange for public disclosure of an invention. So basically, this is a system that the governments put in place to encourage and promote invention in exchange for publicly disclosing the idea. Inventor or the assignee receives the exclusive right for a limited period of time. And these rights protect him or the company against importation, exportation, offer to sale or use of the patent technology, only in the patented country. So to get a patent, the idea must satisfy the 3 conditions: novelty, non-obviousness, and utility. So novelty basically means like some aspects of the invention must be new. There must be some inventive steps in the idea. And non-obvious means like the invention shouldn't be obvious to somebody who is skilled in the art. So for example, optimization of a process usually is not considered a new invention. And utility is the last condition, and basically means that the invention must have some credible application. So with that, let's look at the typical patent. Like in patent, you will see different sections. It's going to be updated quickly. Just a second. So you will see different sections in every patent, and the most common sections are claim, description, and drawings. Description is the body of the patent, or the place that the invention is described, and drawing basically are different figures that disclose the different features and aspects of the invention. And the claim is the most important of the part of the patent. Basically, is the legal language where, using words, the patent attorney or patent agent describes the invention. So all different elements and features of the invention are included in this claim language. And each patent may have more than one claim. So this is the part that basically is used and can be asserted or enforced in court. So with that, let's look at prior art. What is prior art? So prior art is basically any information that has been disclosed publicly in any form before a given date, which could be relevant to the originality of an idea. Basically, any example of that are any patents, patent applications. Patents might be US or foreign patents, or any books or papers, for example, conference or journal papers, or it can be even a product, the actual product, or data sheets or product brochures, white papers related to a product, and sometimes even web pages if they have the date information. Basically, any clearly dated, publicly available document can be used as prior art. So now, knowing the definition of prior art, there are types of patent search that can be useful for different purposes. You will see like there are many different types of searches here. The most common search is patentability and novelty search. This is the type of search that the inventor usually uses, to see if the idea is really novel. So it's in early stage, for example, when you want to file a patent or protect your idea, you just do this type of search to see if anybody else has had this idea before by looking for prior art. Another type of search, validity or invalidity search, is used, for example, in litigation or licensing. When somebody is sued, usually the defendant tries to check the validity of the patent. And this is done, again, by looking for prior art, like looking for any existing document before the date of the filing, or usually the priority date of the patent, that may be discussing or disclosing the same ideas that was disclosed in the claim of the patent. Clearance, or sometimes called freedom to operate or right to use, is another type of search that's done, again, when, for example, you want to launch a new product or design a new product. By doing this search, you try to identify any patent and see if you can freely launch your product without infringing anybody's patent. There are other types of search, as you can see. For example, infringement or out-licensing is to discover an infringement by searching for a product or commercial use. In licensing or technology acquisition is another type of search used when there is a gap in the technology and you want to license a technology. State-of-the-art and landscape searches are two other types of search that's not focused on one particular patent, but usually is a broader study to discover the whole landscape and see what is the latest state in a specific technology. Okay, so now the search strategy. Obviously, there is no one way of doing search. There are many different ways that people do this search, but one of the best practices, we're trying to cover that here. So we have divided the whole process into 3 phases. Phase 1 is preparation, before you begin the search. Phase 2 is the actual search, and the final phase is reporting the results. So let's start with preparation. So this is the phase 1. At this point, you need to make sure that, first of all, you're familiar with the problem. You need to identify the search terms and also where you want to search, basically the search domains. So the first step is to make sure that you know the problem, the requirement of the search, the main concept. For example, if it's a patentability search, make sure you know the novelty and what is the main concept in the search. And sometimes there are what we call auxiliary concepts, like the idea might have some features, and those are critical and makes the whole idea different. So you also need to understand those features and those auxiliary concepts. And at the end, you need to make sure you know the function. Okay, what's the application of this idea or this patent? So once you're familiar with the problem and with the requirement, it's time to identify the search terms. So you start this by, for example, listing all the synonyms. You know the main concept, so you list anything that, any word or phrase that can describe the main concept and their synonyms, because not every patent or prior art uses the same set of words. Then there are classification codes that I didn't cover in this presentation, and hopefully we will cover it in future webinars, but these are codes that are designed by different patent offices around the world. For example, there's international patent classification, European patent classification, or US patent classification, and they're used to categorize different inventions. So that's another way to making sure you know the classification of this invention. Assignee and inventors are also very useful. So knowing the company behind the idea and their area of research sometimes helps. For example, if there might be similar ideas that the company is working, and by knowing the assignees, you may be able to identify the right prior art faster. Inventors and looking at their work, for example, the co-inventors might bring more value and lead you to new discoveries. And even like looking at forward and backward citations, like references of a patent or prior art, can lead to new discoveries. So once you've identified the search terms, based on the problem, you need to identify the search domains. So for example, if it's a freedom to operate search in the US, you only want to look at US patent database. Sometimes if patentability search, you need to look everywhere, like globally. So non-US patent or non-patent literature, for example. Or sometimes you want to look at data sheet and products as well. So at this stage, you are pretty prepared for the search. And the next phase is the actual search. So you see, basically, again, we have kind of divided the whole search process into 3 steps, repetitive, that you're going to continue till you find the right, narrow down the results. So in the first step, you define the search query. And this can be done by combining the synonyms that you listed, like, for example, classification codes, assignees, inventors, or like I said, looking at forward and backward citations. And you can create these search queries in many different ways. For example, some sites offer different operators such as Boolean and proximity of operators. So depending on the search tool you're using, you design these search queries, and you run the search query and you filter the results. So the next step is analyzing the results. So you review and compare the different references that you found, and during this analysis, it's important that if you have a good understanding of the search problem, for example, the claim of the patent, you do side-by-side comparison with the claim and make sure what is relevant and what is not. So based on this analysis, you go to the next step, basically refine and redefine the search query. And this can be done by removing some of the synonyms and terms, or maybe adding some new synonyms or classification codes, and basically you narrow down the search. So you continue doing this till the moment that you feel comfortable that the results are satisfactory. And that's the time for final phase or reporting. So during this phase, basically you narrow down the results and you review all the references. Sometimes you need to combine some of the references to, for example, show obviousness, and do a side-by-side comparison with the claim. So once you know the final results and all the references, you start putting together the final report in a written format. And there is no single way to do this, but usually reports have like the following sections. There is a summary, there is a description of the problem and the subject of the search. The reference discussion is the most important part of the report. Basically, at this place, you do a side-by-side comparison and you discuss every reference and how it is related to the claim or to the search problem that you were working on. So sometimes you do, like, there are different ways and formats that you can show this. Sometimes you do side-by-side, divide the claim into phrases, and you do a side-by-side. It's called claim chart. Again, hopefully we will show that in more details in future webinars. And basically in this section of the report, you do the comparison and review the results. And at the end, sometimes you include the search history and all the queries you had used, so for your own reference. So having said that, I'm going to share with you in a couple of slides basically some of the references that or resources that you guys can use to do the search. Some of them are free. Usually most of the patent offices around the world, they have their own database and it's available for free, USPTO, EPO, or WIPO. And depending on the search, sometimes the search is very technical and you need to use very specialized databases. For example, in biology or chemistry, computer science or electrical engineering, there are other dedicated databases that some of them are available for free, some of them are available by subscription, and you can use to do the search. So this was basically our first webinar. I hope you found it useful. And at this point, if you have any questions, you can tweet it using your Twitter account to @Petexia. I'll be here for a few more minutes to answer your questions. And don't forget to send us your feedback and suggestions to webinar@Petexia. We plan to have another webinar next month, hopefully on defensive publications. And as I said, like every second Thursday of the month, we will have one webinar. So these slides are going to be also available on our website. You will all receive the link, and the webinar will also be available in our website and Google Hangout. So if there is any question, feel free to send it using your Twitter account. Okay, somebody asked what is a claim chart. As I said, hopefully we plan to cover that in our future webinars, but claim chart is something that usually the attorneys use to see the relationship of a reference to a claim. We didn't go into details about different claims of a patent. There is independent and dependent claim, but these are done usually by forming a table and dividing the claim into phrases that describe different features of the invention. And then on the other side of the table, you show exactly what part of a reference is related to that particular feature in the explained in the claim. Okay. Thank you so much, everyone, and hope you enjoyed the webinar. Have a nice day.